Welcome to Conversations with My Real Friends. I'm here with my friend Janice.
Nice to be here, thank you.
And I'm Jennifer, and we today are going to be talking about the documents that owners should have when they're entering into some form of partnership relative to ownership of a business.
Correct.
So both Janice and I, in most cases, will likely recommend some sort of limited liability company like a corporation or an LLC. But if there's going to be two or more members, they better have a contract, right?
Yeah. So that's a great question. A lot of times people do handshake deals. They think, oh, it's a relative, it's a dear friend, it's a good friend. I'm never going to have a problem at all. Let me tell you an example. We represented a company. It's like a joke, but it's not really a joke. We represented a company with 4 members. Early 50s, mid 60s, late 60s, and 70.
Right.
No shareholder agreement. They've been operating for about a year or so.
Okay.
The 50-year-old had a stroke. 50-year-old was the president of the company, was making presentations outward and stuff like that. It took us about a year and a half to clean up that mess.
Right.
Because at the time they formed the company, if they had entered into either a shareholder agreement or what's called a buy-sell agreement, the parties would have not had that. They would have had a roadmap or a path forward if just something happened. Let's talk about buy-sell agreements for a minute.
Yes.
So when you form a company, whether it's a corporation or an LLC, the buy-sell agreement says, what happens if I no longer want to be here? And there's something called a triggering event. Now, the purpose of our conversation is general knowledge. It's not meant for specific things, so legal disclaimers, legal disclaimers. But generally, there are 4 basic what we call triggering events or items which would have a company review this document that they enter into. We call it the 4 Ds, right? Death, divorce, disability, or dissolution of the company or something like that. There are many other things, but companies need this document, a governing document of the company, to help determine how, if something happens to one of the members or shareholders, they go forward. And in the example I gave, the company didn't have a shareholders agreement. If you think about my background's journalism, if you think about who, what, why, where, when, and how, if you think about all of those aspects when forming your company and take care of your business ahead of time, if something happens down the road, you'll be protected and provided for.
And we'll have a plan to move forward
100%.
Versus everybody having their own ideas about what's fair and what's reasonable.
And how that particular member or shareholder is no longer going to be in the company. What's the cost going to be, excuse me, to remove that person? And how, and the mechanisms for doing that, et cetera. Or God forbid somebody passes away, how will that company survive without that company? There was a recent Supreme Court decision that talked about insurance and how that all calculates in the Connolly case, how that all figures into buy-sell agreements now and stuff. So I guess the key thing here is be prepared. Speak to a lawyer who can help navigate some of these things for the companies, because in most cases, business people are amazing at what they do, but they're not lawyers. That's what you and I do, what we do.
So if someone needs some help putting a buy-sell agreement together, and by the way, you can do it after you form the company while you still get along. How do they reach you, Janice?
Great point. But don't wait too long. Best time to reach me, or best place to reach me, is at our company's website. So that would be millerhaga, HAGA.com, or my email, jmiller@millerhaga.
Great.
Thanks, Jen.
Thanks, Janice. And thank you for joining us for this episode of Conversations with My Real Friends. We're glad to have you.